Hello, this is revision tips for SIPS Level 5 Advanced Diploma in Procurement and Supply, Module 3, which is Managing Contractual Risk, and its Learning Outcome 2, which is to understand and analyse the impact of breach of contract and the coping strategies and provisions that are available. So we will look at the different levels of breach of contracts, compare and contrast the tools and techniques that are available, and the different organisational responses to a breach of contract. So a breach of contract happens when one or more party does not fulfill the terms or clauses of a binding agreement. Now, this opens up a possibility of financial damage and a range of consequences. The degree of which any financial damages and additional remedies are awarded will depend on the type of breach and the impact it has on the other party. So we'll start with a condition on the left-hand side. A condition is a fundamental term of the contract. A breach of a condition can lead to the contract being terminated, and the innocent party can bring a case for damages. The warranty is a minor term. In the event of a breach of a warranty, the innocent party can claim damages, but may not terminate the contract. And then finally, in the event of a breach of an inanimate term, the court will decide whether or not it's actually a condition or a warranty, and the consequences will determine the options available to the innocent party. The two main options available to the parties in conflict or disagreement resulting in a breach depends on whether their breach goes to the root of the contract. But the innocent party can exercise their right to terminate the contract, or the parties can affirm the contract if they wish to continue. There are various levels of breaches of contracts. The minor breach or partial breach is where the actions of one party doesn't have a serious harmful impact on the other party. So, for example, delivering goods one day late, unless the contract specifically states time is of the essence. The damages awarded for a minor breach of contract, if any, will usually be limited to the costs associated with correcting any damages of the breaching party, correcting the damages at their own expense. So a resolution would be working with the default party to correct the impact as soon as possible and to reduce the likelihood of it happening again. This helps not only to reduce occurrences in minor breaches, but also to minimise the impact they'll have on the performance of the contract. A combination of minor breaches may be deemed as one major breach, as in the case of GB Gas Holdings versus Essentia in 2010. But a major or fundamental breach occurs when the actions of non-action of the defaulting party seriously impacts the performance of the contract to the point where the default and it defeats the whole purpose of the contract in the first place. So let me give you an example. If a buyer places an order for 8 new stone pillars to be used in a building project and the supplier is only able to provide 3 partly worn pillars, this would require a complete change of design and would affect the timescales for completion of the project. The outcome is the innocent party would be entitled to terminate the contract and bring a case against the breaching party for any damages that might have incurred, like claims for losses from the end customer or cost of finding alternative suppliers and so on. Now, prior to prosecuting, the innocent party will need to check the progress agreed in the contract for terminating the contract and what constitutes a material breach. If a claim for a major breach is made, courts will consider several factors before awarding damages, such as the impact of the breach, how easy it is to remedy, performance to date, the remedy of the situation, and the intentions of both the breaching and innocent party, as well as the contractual terms. And there are two other types of breaches. So the principle of a fundamental breach, now used in all contracts, it signifies a breach that's so severe that it will affect the fundamental nature, performance, and existence of a contract. So fundamental breach is usually read as a reference to some sort of breach of contract unless the contract expresses a different intention. So the breach must go to the effect and root of the root of the contract. It must not, or it must at least affect the very substance of the contract or frustrate the commercial purpose of the deal in the contract. So considerations include the surrounding circumstances of the contract and how the term in question affects the transaction that the contract was intended to carry out. But an anticipatory breach arises as an indication in advance by a party that it does not intend to fulfill the obligations under the contract. So an anticipatory breach occurs before the time comes for the party to perform the contract. They declare they're not going to do so. This repudiation of the contract obligation in itself is a breach of contract, and the innocent party may choose to either accept or reject an anticipatory breach. If he accepts the breach, the contract is terminated and the innocent party can sue for damages immediately. But if it's rejected, then the contract remains on foot. And if the innocent party elects not to accept the breach and keep the contract alive, then they may proceed to perform his side of the bargain and sue for the contractual price. So an anticipatory breach of contract is a repudiation breach in which takes place before the contract performance is due. The innocent party in this case has two options: accept or reject. There are all relevant examples here that can be used in a mini case study in your exam. What you're showing here is the intention that a party is no longer considering themselves bound to the contract. And this could probably be satisfied in circumstances such as denying access to a property that's required by the innocent party to perform the contract, or a supplier saying that the goods won't be supplied when the time to deliver them arrives. A party becoming unable or incapable of performing the contract despite genuinely saying, I want to perform or I would like to perform, but I cannot. These expressions translate in law to I will not perform. A party says that it intends to perform the contract in a way inconsistent with the terms of the contract, or a party wishes to impose additional terms on the performance where there is no legal entitlement to do so, and that is the additional terms do not perform or do not form part of the contractual relationship. So what this is showing us is that there will be times where we need to go through conflict resolution using negotiation or other sort of forms of dispute resolution. So conflict resolution, there are various methods and processes that can be used to reach an agreeable, amicable solution to a conflict. Ideally, obviously, win-win, but we need to identify the nature and source of the conflict and assess the impact of the breach, how the consequences can be contained or mitigated, and the solutions and remedies. Parties agree a way forward to resolve the breach, culminating in a signed agreement that can be agreed and added as an amendment to the contract. There are various options for resolving conflict, from escalating in terms of time and effort required. From negotiation to mediation, conciliation, adjudication, arbitration, and litigation. The terms and conditions within a contract will state which process is going to be used. So negotiation is where the meeting of the parties happens to resolve the issues between them. A default method for resolving disputes that occurs due to a breach of contract. And this should be explored before other methods. There is a different approach adopted by the parties in negotiation that will impact the nature of the negotiation. So obviously, if you're trying to both please each other and find an amicable mutual solution, it will be a win-win outcome. But if one's trying to get one over on the other, then it could end up as a win-lose or a lose-win. But moving on to mediation, a negotiation between parties in the presence of a neutral third party. You can see that on the screen. This is informal and voluntary. The mediator has no decision-making powers and cannot make any legal judgments. But the mediator's presence can change the dynamics of a negotiation and results in a less competitive and confrontational process, enabling a resolution to be agreed. Mediation consists of 4 stages. Introduction. So the mediator introduces all parties, explains the goals of the mediation, and encourages both parties to work collaboratively. The disputing party may also be invited to describe in their own words what the conflict is, and their position in terms of how they've been affected. The disputing parties may be encouraged to suggest how they would like it resolved. Then there's a joint session where the mediator may attempt to make or to get the disputing parties talking directly about what they've said in the opening statements and identify where the key issues are. Typically, a key issue might be the obligations of the contract. Each party then has a chance to meet with the mediator privately to discuss the strengths and weaknesses of their position. From this, new suggestions could be made on how to reach a settlement. The mediator may meet with the parties privately several times before a new resolution can be made. And the final stage is the agreement, the end phase of the mediation, where the mediator summarises the progress that's been made. But if no agreement has been reached by the end of this process, the mediator will advise other options, such as meeting again or going into arbitration. Conciliation and expert determination is where you use a third party to hear the concerns of all the parties involved, then suggest a resolution and propose a non-binding agreement. The parties can then decide whether the solution proposed by the conciliator suits their needs. The goal is to find a resolution that best suits the interests of the contract rather than one of the parties. The process is less formal than arbitration, but the third party takes a more active role than the mediator. Conciliation is a voluntary process. Parties cannot be forced to enter into conciliation against their wishes. Adjudication uses a hearing to find a resolution to the conflict or the breach. Both parties address the adjudicator rather than each other. That allows parties to resume performance of the contract in a timely manner. It's a quick and efficient process, most commonly used in construction industry. And then arbitration is used in a neutral third party to reach a decision about how conflict should be resolved. A structured method that has dialogue between all parties. The parties agree in advance and abide to the decisions of the arbitrator. The outcome is binding and enforceable by law. And there are some instances where arbitration may be an option, for example, if there was a dispute over intellectual property rights. And then the final one is litigation. Litigation is the process of taking legal action to resolve a breach of contract. Uses the legal system to decide the remedies that are deemed appropriate in a way that represents the legal system referred to in a contract. It follows a set procedure, but there's not a determined time limit for completion and costs can escalate quickly. All parties are required to be present for an oral proceeding, and the details of a case can be made available to the public, which removes any confidentiality. Litigation commences when one party sends a formal notice to the other party detailing the basis of a claim and giving them the opportunity to respond in detail. Should be used as a last resort. It needs to be able to show that the other forms of conflict resolution have been considered and offered. But here you can see the advantages and disadvantages of litigation. So the process ensures that a decision will be made, providing certainty that the outcome will be reached. Decisions may give rise or make use of precedents of previous cases of similar nature. Judges can compel parties to act. The use of lawyers and expert legal determinations can help identify risks and act as a buffer in some unpleasant aspects of the process. But the downside is that the process is available to the public and there's no confidentiality available. It can be costly and lengthy as you need to go through steps. The final decision may not be made by someone who is an expert, so may award something that's fair or not fair in some circumstances. By its nature, the process promotes an adversarial encounter, which is likely to damage future business relationships. And it's seen as a process of winning arguments rather than solving problems. Now, when a contractual breach occurs, it can take some time to reach a resolution. Completion dates are usually fixed, so an organisation may elect the subcontractor to work. And subcontracting occurs when contracting other parties to undertake work in order to ensure completion dates can be met. It usually results in higher costs due to time pressures and the pressure of working to a standard that's acceptable to all parties. Such costs are likely to be paid for by the end customer. They will need to be settled by Tier 1 and Tier 2 suppliers. This enables the Tier 1 organisation to satisfy the customer and promise a positive image of the Tier 1 organisation for future work. Alternative suppliers for commercial off-the-shelf items are easily obtained, but longer discussions will need for customised items. And the benefits of subcontracting need to be weighed up. Other important considerations when identifying subcontractors to help restore performance of a contract would include the costs, the availability of the subcontractor who can work to the same standards, the capacity of the subcontractor to work to the required time, quantity, and quality required, and the experience level of the subcontractor. Now, reputational damage, the aim here is to take whatever action is necessary to prevent damage by compensating customers. Reputational damage is the realization of any source of reputational risk facing an organization or an individual. It can be caused by a number of issues, but ultimately its source is a negative shift in perceptions from a stakeholder group linked to the perceptions of the company's behavior, performance, or communications. And reputational damage often results from a gap between what a company says they're going to do and what they've actually done. This can encompass a wide range of issues, including, but not by any means limited to, regulatory breaches, the CEO's misbehavior, employee indiscretions, cyber attacks, damning consumer reviews, or critical social media posts. How a company responds to a damage then determines the severity of the reputational impact. Failure to clearly communicate with stakeholders about the situation or the ability or inability to halt negative media coverage or the lack of effective or immediate response can all result in long-lasting damage to a company's reputation, which may ultimately cost enormous sums of money and years to rectify. Johnson & Johnson is a case in point, a household name trusted by generations of families. The company has weathered reputational storms over the decades, with a keen focus on stakeholders over shareholders, corporate social responsibility, and exemplary crisis management. Yet over the last 2 years, the pharmaceutical giant has seen cracks appearing in its reputation. Lawsuits over tainted baby talc, blood-thinning deaths, and faulty pelvic mesh implants, and the allegations over its role in many crises have all taken its reputational toll, especially with the media and its once loyal customer base. The claims management process depends on there being a party against whom a claim should be made by. Underwriters evaluate insurance applications by analysing risks involving using statistics of probability, especially the higher the risk, the higher the premium. An important part of an overall risk and insurance process is when claims have to be made. This flowchart shows you the steps involved, but notes that there will be often an external party commissioned by the insurer to assess if a claim is paid, and the amount is paid by the loss adjuster. So the event has to actually have occurred, the loss event. The insurer makes the claim, the insured makes the claim, and the insurer investigates that. They will then employ that loss adjuster to determine or negotiate compensation, and then they pay the amount minus the excess. So that's the end of Learning Outcome 2. Thank you for watching.